what can state, local, and tribal governments do? You've heard a lot about this already. And in some ways, I'm going to go back to some of Janie's remarks or others that you've had throughout the day. To answer that question, I want to turn to the California law, which required the railroads to have oil spill response plans and to demonstrate that they had the financial ability to clean up a worst-case oil spill. There were also fees on the oil that was landed in California. And it's an interesting case study because you have polar opposites in the perspectives that were presented to the court from the railroads on the one hand and from the state of California, and there we were representing San Francisco Baykeeper and a wide range of groups, and so on our side. And so I know a lot of you are wanting to, what are the rules? Well, there's a lot of gray area here, but at least this will tell you some of the bookends and hopefully some of the principles to use to analyze this issue. So California has long had an oil spill planning regime, and what they did is extend it so that it applied in fresh water. It had applied in coastal and marine waters. So this is a general law. It had applied to refineries, and it applied to tankers. Now it was going to apply on land to railroads, pipelines to some extent, but it was really targeted at the railroads. So what the railroads said is we are an instrument of commerce. The federal government regulates that under the Constitution, and they have a very good point. I would say, I don't want to be on TV and recorded with things that could be used against me in court, but what I'll say is I would be wary of any kind of a state or local or tribal law that blocked the train at the border, that said, for example, this train cannot come into California because it does not have an oil spill response plan approved by the state. That would be a problem. The railroads also said there are all sorts of statutes that say it is the federal government's prerogative to deal with certain matters, and that is true. That would be some operational issues like the routing of trains. Speed limits in most situations, unless there's some very unique state or local issue. Other issues about who can run the railroad, are they solvent, that kind of thing. And the tank cars. What are the tank car standards? What kind of tank car must a certain material go in? How to classify the hazardous materials in figuring out the kind of labeling they need, the tank cars they need to go in. That's the federal sphere. Wouldn't want to touch that. But there was another aspect of what the railroad said, and that is, Janie had mentioned, if there's a federal standard on rail safety, then the state, tribal, local governments are ousted. But what the railroad said is that standard can even be a decision that exempts the railroad, goes pretty far. I liked being able to take that one on. And so they said because the federal government had essentially exempted the railroads, that meant they were supposed to be exempt. So what did our side look like? Well, it looked a lot like what Peter was talking about. The state of California said this is a law of general applicability. It's a health and safety law. It's applying to all sorts of industries. It's even-handed. And we said it is issued under a law that expressly preserves state, local, and tribal authority. That law is the Oil Pollution Act of 1990. We call it OPA, like a nice German grandfather. And it says the federal standards are the floor. States, tribes, local governments can go further. We want them to go further. We want there to be coordination, maximum preparedness. And so you have express preservation. And it goes pretty far. And so let me just give you some examples of what is expressly preserved. It is expressly allowed that, I'll just say state here, it's absolutely clear it's all the states, can impose liability, including strict liability for an oil spill. It is illegal to spill oil. And so a state can say anyone who does that in this state is liable for all of the property that's damaged, all of the health harm, the human lives lost, and to restore the natural resources to what they used to be. States absolutely have that authority. And they can even have punitive damages under their state schemes, under whatever their state common law would allow. Second, there's no question that the state can require fees on oil landed or transferred in the states. I wouldn't impose the fee on the oil that's going on the railroad and never leaves it. Once it leaves and it lands in the state, there can be a fee. These fees can go into oil spill cleanup funds. The federal government has them, California has them, Washington has them, and interestingly, the railroads didn't challenge that in California, and they went along with that in the Washington legislation. Absolutely no question. Oil spill response planning, I think that's pretty clear too. And I wouldn't say just the oil spill plans, but everything that goes in them, which is training and the equipment and the communication systems that are required, reporting, having responsible officials who will be there on site, who can be located, who can work with the other emergency responders. That's going to play out in California. We will start to get legal decisions on that issue, but I think we have the better argument. And then the last thing that California did was require the financial responsibility, insurance or bonds, self-insurance, to be able to clean up a worst-case spill. I want to fight that fight. I think we have the better argument that the states should be able to require that. There is no federal regulation requiring that. They haven't occupied the field. I think because, and any of you who've looked at this issue know the railroads are underinsured. They couldn't get enough insurance for a Lac-Mégantic. And so it's a problem, and if they make the argument this will prevent the trains from running, they have an argument. But I think that's a battleground we want to have. And so hopefully this gives you a sense it's not cut and dry, but we want to pick some of these fights. So part of what we're doing is we want to win, but this is the dialogue we want to have. So let me take this to 3 areas of what state and local governments can do. One is making law. The second is projects, permitting and approval of projects. And the third is advocating to the federal government. So in lawmaking, I've already covered some of the oil spill response and preparedness, and I think that is fair game and areas that state and local governments, tribes should definitely be fully engaged in. Second, and we've talked about that a bit, is right to know. And I know it's not necessarily popular, but I think we need to look at this in 2 ways. What does the local government, and I'll just say local at this point, what does the local government need to know? I think they should push to the max to get all of the information they need to know to protect their people, to have the emergency responders be able to respond. But to push that to the max, some of that won't go to the public. And I said that may not be popular, but I'll just tell you under the laws, that terrorism planning you're not going to get it unless the federal law changes. And so if you're looking at what they can do, they could really push hard. They might have to sign secrecy agreements, but to get a lot of that information. And the second is pushing for maximum right to know for the public. And that's an area where I think the state, local, and tribal governments should push hard. And they have been very vocal. And some of that is what they can require and make public. And the other is when they get the information from the federal government, it was all the state public records laws that dictated whether it would be made public. Most of it was. And the 2 battlegrounds were Pennsylvania and Maryland, where you had an administrative board and a court rule against the railroads. And so any contested case went for us. A third area, and we haven't touched on this very much, but is vapor pressure, the volatilization of the crude. That's an area where I think the states in the first instance should push. North Dakota has a standard. Railroads haven't challenged it because it's not very meaningful. But it's an area where there's no federal standard. So preemption under that theory should not exist. And so that's kind of an open field to start acting in that area. So second category, projects. And there's kind of a different lens if it's a new project or an existing project. If it's a new project, so you've got a local government or a tribal government that's going to be doing the permitting. And as Peter said, there are a lot of laws about permitting, what can happen where, air pollution, water pollution, noise, traffic, all of that is well within the purview of a local government. And it's a lot easier to stop a new versus an old. The general principle, though, that could get a local government in trouble is if it's so connected to the railroad and transportation by a rail carrier. A lot of these projects we're talking about are not the railroads. There's some other commercial enterprise that wants to have a storage facility, that wants to take the oil and put it on a barge or somehow transfer it somewhere else. That's not a railroad. That's something I think we have the better argument. And so the local governments have the ability to decide, applying their normal permitting laws, whether this facility can be permitted and can be built. A lot of these projects are changing a facility from one use to another. There's still going to be air permits. There's still going to be issues about what kind of water pollution that you have. And in states that have environmental impact assessment laws, that's a huge, huge benefit, and that should apply fully. We've seen in most of these situations, the proponents in the state or the local government have gone along and said, it's not really a meaningful change. But a lot of them are backing off. In the Hudson, they backed off in the first round. In Richmond, we're still fighting. In Sacramento, they backed off. And so I think there, now that people are paying attention, we should get that kind of review. In the states that have environmental impact assessment laws, this is democracy in action. Because then you start to get disclosure. There's a lot that you learn about these projects that otherwise you would not know. You get public participation. We have seen people come out at hearings in places that they never saw anyone comment, and they've had to have a full day of commenting on a crude by rail project. And it starts to make people, the press are there, the elected officials are engaged, and we've won in very conservative venues where they'd never seen these types of issues come their way again. And you get validation. So up in Skagit County, which is a very rural conservative area in Washington state, the hearing examiner, who seemed a little shell-shocked, and this was a Shell refinery rail loop, but he seemed like not to know, wow, what do I do with all of this attention? But in the end, he said there was no proven basis to the arguments that the federal, state, and local regulation was sufficient to protect the people from this rail project and from crude by rail. So our position was validated by this neutral decision maker who made that decision based on the evidence. The other thing that happens in the course of these review processes, and if you're a state that doesn't have environmental review laws, sometimes this will happen in permitting processes where there's public comment, and you can get your decision maker to bargain with the facility. So, for example, in the Shell loop and in some of the others in Washington state, the railroads are saying, or Shell is saying, oh, we won't use this kind of tank car, or we won't go faster than the speed limit in particularly this area. And you start to get some concessions, some promises. You can start to hold them accountable. Not a panacea, and it's going to be a lot harder to kill a project than mitigate it using a lot of these permitting processes, but mitigation sometimes makes it die. And so, it could happen. So the third area is being an advocate. And the state, and particularly the local governments and the tribes, I think are incredibly effective advocates because they have their people coming to them and saying, our public's demanding protection and we can't give them what they want because of preemption. We need you, federal government, to protect us. And when Ben mentioned the meeting we got with Secretary Fox, and Vivian was there as well, we asked for that meeting on behalf of the local governments and got it. In like 8 days, we got that meeting. We wouldn't have gotten that meeting with the secretary. We would have been shunted to some lower level person. And he enjoyed and respected speaking with local electeds. They had the validity that he respected as appointed by an elected. There was a dialogue that a conservation representative would not have had. He stayed longer than the appointed time. That sort of thing doesn't happen. We had a meeting with Senator Risch from Idaho, something that none of my conservation colleagues had had, but we had the Sam Point city council member there. So the state and local government should be heard on tank car standards, which are not good enough, weaker retrofit standards, long phase-out periods, the fact that the new tank car standards will only apply to these large unit trains. That there's advocating for a volatility standard. The local governments can also petition for place-based rules and get exemptions from preemption on that basis. Oh, I want to mention the tribes. So two last points. One is the crude oil export ban, which I'm so glad was mentioned before. That is something where we need the voices of the states and the local governments and the tribes to be advocating to Congress, because it's Congress now that's talking about repealing that ban, and then game over. Nobody's talking about crude by rail in that context. Nobody's talking about environmental harm. They're talking about gas prices. They're talking about the economy. And so that voice really needs to be heard. And the final thing I want to mention is with respect to tribes. So tribes are a government, but they're different in that they have greater powers in some way and greater authority in some. First, they have territorial sovereignty that is different in kind from the states and the local governments. So, for example, the Swinomish tribe in Washington State is suing BNSF for crossing their reservation and breaking a deal where they have a limit on the number of tank cars, and they were supposed to disclose what was in them. That's something that is uniquely a tribal right to protect their territorial sovereignty. The second is the tribes have treaty rights. These are not rights that were given to them, they were retained. They were their rights before white settlement. And they can sue to protect them. They rarely do because that's their future, that's their essence, but the Lummi Nation is putting their treaty rights on the line now with coal exports and a coal export terminal. And in Oregon, one of the reasons a coal export terminal permit was denied was because of treaty rights and salmon fishing rights. It's really very powerful in my region of the world. And the third is tribes have a special relationship with the federal government. Since the federal government entered into the treaties with the tribes, they have a fiduciary responsibility to protect those rights. And that includes consulting with the tribes on a government-to-government basis. That has not happened at all on crude by rail. And there are several Columbia River and Washington treaty tribes that have appealed the tank car rule on that basis. And it was really kind of a back-of-the-hand response, and I can tell you the tribes are not happy. Because the argument is really, you're no different, and we let you do public comment. So the tribes have been a huge voice in the Northwest on these issues, and one that has gotten a lot of attention. I see. I'm done.
Thank you so much.